Hey, good morning, everyone.
Good morning, folks.
Hi.
Good morning. Can you guys hear us from back there? Awesome.
Woo! Chicago Code Camp 2018, our 10th anniversary year, huh? This is going to be awesome.
Who was here on year 1? Okay, that's quite a few people. Year 2? Okay, last year. That's more like it.
Yeah.
First year? Okay, welcome.
Not for sure.
Who was here last year? It'll be better, I promise.
Yeah, on behalf of the whole, Chicago Code Camp team, welcome to Chicago Code Camp 2018. We got a couple of things we want to announce, and we have a full day of speakers and events going on today. Thank you for coming. Min, you want to announce the speakers, sponsors?
I will announce the speakers too. But
Yeah, that too.
So today Microsoft is coming in as our prime sponsor, followed by Illinois Institute of Technology, which gives us this venue at a discount rate. And we also have Polaris Solutions and Concurrency as platinum. And then we have Coyote for gold. And then we have platinum recruiting, West Monroe, Label Insight, and Inbox 3D, who came in at the last minute as silver sponsors.
Yeah, so if you guys actually do see them in the hallways, go say hi to them, etc. Right? If it wasn't for those guys, and obviously, and to some of you guys, we won't be here today. So for the 67 people that actually, did give us some money, thank you.
How many of you guys? Who's on here? Awesome.
And for those of you guys,
Thanks,
thank you.
So if you need help throughout the day, we actually have people wearing gray shirts, the same versions that you guys have, but in light gray.
Look at
like
Jason. So go find those guys. They can actually help you around, etc. Right?
Your badges, if you haven't noticed, they have a Wi-Fi code underneath. You need to connect to, I believe, IoT Connect and use the Wi-Fi code, and you will be able to have free Wi-Fi for the day. And then obviously there's a QR code. If you want to give your information to the sponsors when they interact with you, they will scan it. If you don't want to give it to them, cover it up. That's all I can say. So let's go with some stats that we've been doing since. It's been about 4 to 5 years since my brother and I have started organizing this event. And then we've added other people on since then. So let's go with some stats, Lon.
Yeah. So this year we have 158 total submissions for topics, and we actually picked 40 of them. So it was a huge amount of people that we had to, unfortunately dwindle through. Some of you guys might be speakers that actually submitted. For those that submitted, thank you for that. In terms of women speakers, we have 22%. That's an incredible climb, right? That from 10% that we had about 3 years ago to today. And in terms of diversity as well, we actually have a number has been slowly going up. So this is actually a good thing and a much welcome thing for Chicago Code Camp. And if you do see everybody, say hi, etc. Thank you for that.
Yeah. So we're not only trying to diversify just our speakers, we're also trying to diversify our talks. So when the first few years were around, we were mainly Microsoft.NET focused. We're trying to incorporate other stuff now, if you haven't noticed. So if you work with other companies or know other people that are in the IT industry that you think should speak in the future years, make sure to get them to submit for us. That way we can diversify the talks as well. That way we can get the other industries. That way we can have better networking opportunities for you guys, right?
And, make things more enjoyable for you, right? At the end of the day, like every year, we actually, once the submissions are once the people have submitted the topics, right, we actually let you guys vote, and we pick up, the speakers from your selections. So this is all powered by you guys, right? And this year we actually did something a little different. Last year we have a lot of outages, as we, Jason implied.
We got offline mode this year, guys.
We have offline mode, so your phones and everything should be running offline. That's one. The other is that every single room that is actually having a talk in will have a screen in front of as well that give you the whole day's topic as well. So you can actually go look at those, and those are highly iterative on our side, so that if things were to change, they will actually change on the screens as well. All right. So go see those things.
So one housekeeping rule. So around lunchtime, you'll be given lunch boxes, as some of you guys know. When you get the lunch boxes and when you're done, take it. So you guys remember what the registration is? Go to the opposite end and
keep going.
Keep going. There's going to be trash bins in that aisle in the back. So don't be afraid of that dark area. Just keep going, and then it's lit. It's lit. You can throw your trash in the designated bins over there, because we have a few janitors that we are paying for, but a lot of it we have to do it ourselves too. So help us,
help you guys, right?
You guys,
Yeah, and ask the crew, right, for directions on where they are if needed. We have obviously bathrooms are over that way as well, and water, so on and so forth, right? Man.
Yep. Privacy. We're trying to get you guys a new privacy system going on our site right now, so that you guys can actually remove all your data since the beginning of time on our system going forward, as well as see what we've been recording. And that will be coming out shortly by the next 2 months. We've just been busy trying to get this event going, so that's where our focus has been. So it's not forgotten.
All right, one more thing, right? I mean, this sounds like NPR. We are a 501c3. Your donations actually do matter, right? So if you can donate, etc., and if you can actually, ask your companies, whatever, etc., for support, we'll appreciate it. Obviously, this is all tax deductible, so just giving you another opportunity. And again, for earlier, those of you that helped out, thank you for that. And I got a quick announcement. I believe in room 103, Microsoft as prime sponsor has been generous enough for us to run a lab. So we are actually going to be running a IoT Labs throughout the day. It will be 2-hour labs. If you have a computer, bring it along. We can actually try to help set you up and keep it going if needed. It will be interactive. There will be Raspberry Pis that are running IoT, and it will actually connect with the cloud and so on and so forth.
There's only one caveat to this, and that is that we can only set 20 people at a time, just for logistic reasons.
So that's that, right?
First come, first serve on the first 20 people.
And again, those are 2-hour labs. So if you actually have sessions that you're interested in, you might want to actually figure out which ones you want to go to. And that's it. I would like to introduce to Daliah. She's a good friend of mine, and she's going to be talking about law and. Somebody have a question? No. And privacy and all the other stuff, right? This is going to be fun. Thank you.
Okay.
I'll give you this,
All
Daliah.
right. Thank you.
Thank you. And we'll swap you out. Min, how do I get into that big mode? I think presentation mode. Oh, present. There you go. And I think you should be good. You can try swap. Hold on. It's not setting.
Jason.
Jason, we're not projecting. Can you check? There we go.
Okay.
All
That
right.
works.
See if you can.
It works, right?
Looks like it does.
Okay.
All right. Well, good morning, everybody. I'm really impressed that you're up. I anticipated that I'd be the first one. They put me first because no one really wants to hear the legal presentation, but it's encouraging to see you all here. This presentation is meant to be kind of an overview, highlights. These are the main topic areas that when I meet with a developer, they ask me about. There's some confusion typically between the copyright scope of protection versus what a trademark really protects you. What happens if you're creating code with a partner for an employer, if you're doing a project at home on the side. So ownership issues, what IP, various different IP laws protect, and then contractual questions. Should I sign that NDA? What is a non-compete? What is a non-solicitation? I hope to be very informal, so feel free to interrupt me at any time. If you have any questions, just ask, and we'll get through as much as we can in the next, 45 minutes or so. So I'll start with the very first and most important area of law that you need to know about. I assume all of you are familiar with what the Copyright Act is, yes? Okay, probably also in the context of open source, which I will also touch on. How many of you have actually registered your own copyright application? One. Why do you need an application or registration to secure your copyrights in the code that you've developed? Not sure. Yeah. Okay. So we'll back up. Copyright 101. The person who creates the original work, an original work can be a photograph. Typically, when you think of copyrighted material, it's a photograph, it's music, it's text, it's a book, it's art, and code is actually considered creative work. So if you're creating code, then the author of that code has the exclusive right to reproduce that work, create derivative works, which I will explain, distribute copies of the work, and publicly display that work. Okay, so when you're licensing code or licensing that picture you found online, you're essentially getting permission from the owner to do one of these things or all of these things. Now, the big one that you need to worry about is this concept of the derivative work, which will also interplay with when you're dealing with open source software. What is a derivative work? What's the intuitive answer? What? Improving the original? Probably a better answer is adding or taking from to create something else. So most developers will take a piece of code, they might combine it with something else to create a new work. So who owns the copyright in the newly developed work? The person who made the work, but what if I use somebody else's work and then created a new work? If I read a book and I want to make a movie, let's not use code for now. I read a good book and I want to develop it into a motion picture. Who owns the copyright to the book? The author or the publisher. And then I create the movie. Who owns the movie? I actually own the movie, but I can't make the movie unless I get permission from the copyright owner to create that derivative work. So there's a fine line between what a derivative work is and what might be a transformative work in the context of fair use, which I will explain as well. But it's important to understand the lingo. These legal words mean something. So one of the other words that I talk about, my clicker's not working. No? Okay, that's good. Okay, so let's go to this concept of license versus an assignment. Intellectual property is the term we use for trademarks, copyrights, patents. Why do we use the term property? Because most of the ways that we transfer IP is similar to the ways we transfer real estate. We just might use different terminology. A license is essentially renting whatever it is you're offering for others to use. So if you've got, back to the simpler example of a photograph, if you want to use a photo on your website, you usually need to either take it yourself or you need to license it. And when you license it, you're getting permission for a period of time or very limited purpose to use that image. Let's say you don't want any restrictions, so then what would you do? You would buy the photo, but that's not the word we want to use because you can buy a license. You would essentially ask for an assignment. So if you've ever read like the fine print of any legal document, you really need to see, I hereby grant to you all rights, or whatever, a limited license, or I'm assigning to you my work. An assignment is essentially deeding the work, and a license is renting it. So when you're going into the licensing concept, you really need to focus on the terminology. Lawyers make their money negotiating these kinds of licenses. These are the main provisions of a licensing agreement anytime you're dealing with creative works. Let's break them down. What's a non-exclusive license? More than one client or person can use it. You develop some code, you want lots of people, you want to sell it to lots of people, right? Microsoft Word, whatever. So they sell lots of copies of this license because it is non-exclusive. What's transferable mean? I sold it, what's your name? I sell the work to, or I license the work to Rob. Rob wants to leave, so he transfers it to, what's your name? Corbin? Corwin, okay. Imagine like a home. You sign a lease, you want to leave the lease, so you transfer the lease to somebody else. A sublicense is different. That's like subleasing, subrenting. You are on the lease for the whole time, but you want to substitute someone in for part of that, but you're still responsible, so you would sublease. Royalty-free. You have to pay for it, or you don't have to pay for it. Royalty-free means you don't have to pay for it on an ongoing basis. There's also geographic restrictions that could say, I'm only letting you use this code in Illinois, or nationwide, or globally, internationally. You need to parcel out where and how you want that code to be used. And on the reverse side, if you're the licensee, you need to ask all of these questions. Is this an exclusive license to me? Is it perpetual? What's the term of the license? How long can I use this work? Where can I use this work? Can I reproduce the work? And most of them will have these things. Publicly display, and so on. And the right to make modifications. When you're uploading code or you're developing something and you submit it to Facebook, YouTube, Instagram, who owns the copyright to the creative works that you've, maybe not code per se, but who owns the copyright to what you've contributed to a social media platform? Who says the platform? Who says you own the code? Who's afraid to raise their hand? It depends on their policy. What's the standard though? Anyone have an, if you're not sure? What is it? The content creator, right? If you actually are curious, and now with all the GDPR stuff, there's a push for more transparency and clear language in both terms of use and privacy policies. And you'll see that if you actually go to anything, like if you go to Facebook's terms of use, they'll say content. Who owns the content? And it'll say you're the author of the content. That's why you can post to Facebook and post to Twitter and post to some other platform all at the same time. However, all of these platforms ask for a very broad license to display the work, repurpose the work, reproduce the work as it relates to the business of the platform. So then there's some confusion. I get these calls all the time. A person will say, I received a scary demand letter from a company because I took a photo I found on Twitter that someone shared, or code that I may have found online that I thought was free to use, and they're telling me I have to stop. Isn't the fact that it was posted on a social media platform mean that I have the right to use it? Or the more basic level, hopefully all you know, is if I found it on a Google search or Google Images search, can't I use it? No, you cannot. The fact that something's freely available, unless it's definitively marked as open source or public domain, unless it says those things, you cannot assume that it's yours for you to use. So a lot of what I do is field calls from really frazzled small business owners that get these demand letters, especially from, let's say, photography organizations that say, hey, you found this image, you put it on your site, you're not making money off it, it's just kind of background imagery, but hey, we want a lot of money. Copyright laws, the statute has a minimum statutory damages provision of $750 up to $150,000 per infringement. So you create code. Let's do it as if you're the creator. You create code. You properly register it within 3 months with the Copyright Office. And you find out that someone else has scraped that code and used it on a different site. If you've done everything correctly, you can sue that individual. You can seek attorney's fees and costs, which is a big deal. Most in our system, you don't get your attorney's fees unless there's a statute that says so. If it was a breach of contract case, for example, you file the lawsuit, you pay your lawyers. Even if you win, you still have to pay your own lawyers. Not the case with a successful copyright lawsuit. So you would send that scary letter and you'd say, hey, I see that you scraped the code. You now need to pay us whatever crazy amount of money, because if I sue you, the sliding scale is anywhere statutorily from $750 up to $150,000 per infringement. If you've heard of any of these downloading cases in the past, both music and movies, that's kind of the range they go in, because you don't have to, even if your one movie would have cost you $1 to view, they can still go and ask for $30,000 for you seeing that, downloading that movie without permission. If you don't register the work within 3 months of publication or before that infringement, you certainly still can file the lawsuit, but you will not be able to avail yourself of the statutory damages provision. Yeah? Great question. So that's something we argue also. So what can't you copyright? You can't copyright facts. You can't copyright formulas, right? Like 2 + 2 is 4. And then it gets hazy. We've had clients who've been accused of taking short codes or like the name of certain files. He's like, I like the way the directory was organized. I didn't copy the code, but I copied the structure of that whatever, that project. And then the other company said, wait a second, our developer saw this in your project, lawsuit. And so you argue, no, short phrases are not copyrightable. It's kind of a weak argument, though. So even though the facts themselves are not protectable, so the default law school case is a phone book case, where one company copied all the addresses and information from another phone book. And so phone book company 1 sued phone book company number 2. And phone book company number 2 said, I'm just copying addresses. Addresses are facts. You can't have protection in that fact. The outcome was the following. Although the subject matter might not be protectable, the arrangement can be. So a menu, for example, is comprised of ingredients. But if I have colors or a certain formula or a certain way that I put that arrangement, I can arguably protect that as well. So I'd be very hesitant to even take components of somebody else's project unless you know that it's OK. In that vein, there is no percent rule. Daliah, I thought there was a 5% rule. If you only take 6% or 10% of something, then that's OK. Not OK. Do I have that up there? I don't think I do. Yeah. How does it relate to? I don't do patent law. Well, patents protect the idea, which is the only way to protect an idea. And typically, software patents are business methodology, so you're not, again, protecting what the software, the outcome, but how you achieve that outcome. So I'm not a patent lawyer. To be a patent lawyer, you have to have a science background that's typically also in computer science if you're writing the claims for a software patent. So sorry, I won't be covering patents. Yeah? So if you're a small company and you license software to a company and that company gets purchased by a bigger company, and the question is what happens? OK, well, it's kind of, it goes to that concept of transferability. So you would have to put that limitation on when you're actually licensing it. Typically, the implied license lasts for the duration of that first license. So if the company had a license to use it until the end of the year, the nationwide company would be extended, unless there's some other limitation, the same license. Then they may have to renegotiate that license. OK, I lost my train of thought. We talked about the percent rule. Fair use. So this is where I was going to enter into the fair use commentary. A lot of people will say, well, I can use this code because I'm helping insert cause. I'm helping like refugees, helping children. I should be able to use this code for free because it's for a good cause. That's fair use. Never heard of the fair use defense? OK. Also, don't assume anything's fair use because it's defense. It's not something you can assert as a, I will use this because I'm protected by fair use. If you were ever sued for copyright infringement, then that's something you'd have to say. And then the court will, on a case-by-case basis, decide if, hey, that that's a good reason. Fair use will take into account the purpose of the work, the nature of the work, yes, how much you may have used, what the impact of your copying was on the original work, and whether your use transformed it to something totally different. Again, I caution, especially in code, you don't have very strong fair use defenses. It doesn't really matter what the cause is, because as you know, even documentaries have to license footage from somewhere else, even if it's a, it's a nonprofit documentary. So don't assume that something's free to use, that it's in the public domain, or that it's fair use. I don't think I talked about public domain yet. Did I use that term? Okay, what does public domain mean? How long do copyrights last? Well, in the United States, how long does copyright last? Yes? Great. You know your homework. So it's 70 years after the life of the author, if it's the author as an individual, or 120 years if the author is a corporation. Which means that unless you know something's older than 120 years, or older than someone's lifespan plus 70 years, it's not for you to use. And then we get confused because this concept of open source comes in, okay? And so we know what public domain is. Public domain means that the copyright has expired. The lifespan of that copyright is over, so you can use it. I don't think that's going to apply for code. We haven't had code around for 120 years. Okay, so then what's this concept of open source software? Why can I use that? Is that not public domain? No. You guys should be experts on open source more than I am, right? I mean, how many of you have worked on an open source project? How many of you signed something when you decided to contribute to that project? How many of you actually read what the terms of that project would be? Okay, right. So most open source, so this is the misnomer. So open source software is certainly protected by copyright. An open source project says, we're setting up this project, and instead of putting all those restrictions on others, we're going to have like inverse restrictions. So typically a copyright commercial code will say, we're the owner, and you need to ask for permission from us to reproduce it, distribute it, make derivatives, and pay us, typically, if you want to use it. So open source software is not free in the sense that it's free, which it is, typically. It's free in the sense that you don't need to ask for permission. You don't need to ask for permission to reproduce it. You don't need to ask for permission to create derivatives. But you will have to, depending on the open source software, make your derivative available under the exact same terms as the original open source software. Some open source software is pretty easy. You don't even have, you might just ask for attribution. Those are the best ones. You could make them restrictive, okay? So clients will come to me and say, okay, I want to use this code, and I want to use it for commercial purpose and make other people have to pay. And I say, okay, well, let's read the first project's code. And then it gets really messy because oftentimes you're using code from lots of different places. You might be using code from 6 different open source software platforms. That all open source software licenses are not the same. Some will say it's viral. Even if a library, even something small, touches this code, it's infected in the sense that you can't charge anybody for that code. Others will say, go ahead, just put a little, tell people where they got it from. So as lawyers, certainly I don't understand the technical aspects of what the code is. I read the English, which is all of you can do too, that says, and they're all very simple licenses. If you use this, do this, or do this, or do this. The ancillary to open source software licensing is this concept of the Creative Commons licensing. Anyone familiar with Creative Commons? So open source software mirrors kind of that easy to use Creative Commons licensing mechanism. It's creativecommons.org. It's trying to empower authors to not have to use us to license their work. And they use little widgets like, if you want to use this photo, you need to give me attribution. If you want to use this photo, you have to use it for a non-commercial purpose, and so on and so forth. So for this slide, depending on where you're working and who's asking you to do something, you should ask these questions. Should you use the open source software? If it's an internal project and you're solving a problem internally for a company, think the answer is a no-brainer. You're not trying to monetize the software. You're trying to fix a problem. And so typically open source software is fine. Or you're creating a website for someone, right? There's so many different platforms. They don't really need to own the website platform. They care about what's on the website, which is separable from the code that runs the website. Yeah, most open source businesses, most businesses that utilize open source do it on a consultative basis. They don't make money selling the code. They make money implementing the code, maintaining the code, explaining what the code is. Yeah. Attribution typically just says in the license or somewhere that's readily accessible, you usually include the original open source license and or you state where the code came from, which is like, it came from XYZ open source project. It's that simple. Yeah. Arguably not, you're offering the service, but you'd have to make available the source code for the platform. So that if I wanted to use the same platform, I could readily access whatever it is you've done with it. Now, your service might be different, right? Like you're making the money from the phone calls that you field or the customization or whatever it is that, you're that source. But yeah, that helps answer. Depends on the usage, but typically if you're using it, and others should be able to use it, you can't kind of restrict access to that. Yeah. Say that again, sorry. If you're adding features to an open source software platform, can you sell it? Depends on the software. Depends on the open source project. The default typically is no. The whole point of open source is that you want people to contribute so that there's a huge body of code for others to utilize and use. Okay. So these are the questions I kind of went through. If the program is modified, can the results be distributed under a different license? What are the risks of combining the program with proprietary software? A lot of you will be tasked with this. We have our business software. We need to fix this one part. Go figure out how to fix it. You find some open source code. It's free. You're excited. But you got to read it because if you're using that free code and it touches the proprietary code, it might make the proprietary code not free anymore, not proprietary anymore. Okay, moving on from open source software, let's talk about this concept of ownership of code. So when we were very broad about open source, everyone contributes, no one owns anything really except the open source project. What happens if you are a freelancer and you're tasked with coding, let's keep it simple. I need one of you to develop a widget for my website, an appointment widget for my website. What's your name? Shaq. Shaq? Okay, Shaq, how much do you charge for this appointment widget development? $250,000. $1 million? Sure. Okay, so I pay Shaq $1 million, and he creates this amazing appointment widget for me. And then my lawyer friend Bob says, ooh, I'd love to use this as well. I'll say, great, I paid $1 million for it. Give me $500,000 and I'll let you use it. Make sense? I paid $1 million for it. Of course, Shaq and I met at the conference, so we just had a handshake deal. Who's the owner of that appointment widget software that I just commissioned? No, we have a handshake deal. I mean, I paid $1 million for it. Do I own it? I do not own it. I am not the owner of this massive project that I paid $1 million for. I have an implied license to use it for the purpose that I paid, but ultimately he developed it and he has the copyright to that code. Okay? So then it's on him and it's his ability to go and resell it to other people. So as a freelancer, as a business owner, if I'm hiring someone outside my company who is not an employee, I must have a work-for-hire agreement or a contract that assigns to me any rights of that person I've hired. Yeah. If he didn't register it, you don't have to register. You really register to enforce your rights into it. So, well, I certainly didn't code my own appointment widget, so. Right, that's like kind of a factual question. I mean, let's assume that there's no debate as to who developed the code, okay? So it's truly crucial if you don't forget any, and a lot of times people think, oh, business owner, person who's been hired. But we've had cases where I hired Shaq and I have an agreement, he understands the importance, I have the work for hire signed with him, and then Shaq goes abroad or goes somewhere and gets a bunch of other people to help him develop the code without a contract. Now you see the problem. We have a contract, but the guys who worked on the project are not bound by one, and now we have a messy chain of title on this code, and guy from, you know, XYZ country comes out of the woodworks and says, excuse me, this is my code. Can't use it. Yeah. Yes. So the ancillary to that is if they are the question was, what if you hire them into the company? If you're a W-2'd employee, you don't own anything. Who owns the work product? The company. Do you need a contract that says that? No. Under the statute, the company will automatically own the work developed by an employee. Now we get into this concept of, what about the work I do on the side? How many of you have side projects? Right. How many of you would theoretically be hired to do those side projects by the company you work for? No. Okay. So if I am a developer for a, I don't know, trucking company where I'm creating logistics software, that's my job all day. And at nighttime, I'm developing a children's app. Okay? We know that under the work for hire concept, anything I develop in my day job is owned by the company, right? So would that extend to the code I developed for the children's app? Question was, am I using company hardware? Let's say you're using company hardware. Who owns it? No, not necessarily. Okay, so the test is the work that you're developing on the side something that would be within the scope of your employment? So you work for the logistics company. On the side, you're like, ooh, I could side sell this other widget that I haven't been assigned or told to make at work. I'm going to do it on the side because I'm industry knowledge. Not kosher. That one wouldn't work because it's conceivable that the company would sell whatever this addition that you've conceived of on the side. It would be within the scope of your employment to develop that type of work. And that's what we'll counsel a lot on. And then we have this debate with our clients. Should you disclose it? Should you not? Do you think they'll care if they find out? Well, maybe this could be a really big thing on the side. You need to decide on a case-by-case basis if it's something you want to explicitly exclude in a contract with your employer, or you want to take the risk and say, if they were ever to challenge the ownership in this side project, I would argue that it has nothing to do with what I did at my day job, and so therefore, you know, back off. But it's something to be aware of. So don't create things on the side unless you are very confident that it has nothing to do with your day job. Yeah. No one cares about what tool you're using. The test is not who's, you know, it's one of the factors, certainly, like to show that this was enabled or paid for by company resources. But the true trust is it something that the company could have asked you to do? It's not yours to open source. He said, question was, what if I want to do, like, you know, help poor children and, you know. It doesn't matter what your reason is, it's not yours. If you're an employee, it's not yours to dictate what can happen to it. You're not considered the author. Maybe. No, during your employment there. Certainly if you're not working there anymore, there's no connection between you and them. Now, remember the concept of the derivatives. You developed something while you're an employee, and you leave and you're no longer employed. can you add to what you developed as an employee? No, because you don't have the right to make a derivative, because the employee does. Okay, so any questions about kind of the copyright question before we proceed? Oh, actually, I would also caution you against working on a project with a friend before you have an agreement in place. A very scary thing is this concept of joint authorship, okay? So I have an idea for a project, I meet one of you at a code camp, and we work together, and in my head I say, it's my idea, I came up with it, I'm just having you develop it for me, and I'll pay you at the end when, when I make money. It's a typical scenario, right? No contract, everyone's really excited, developer thinks he's, part of a business, idea person thinks that, developer is just a necessary evil, and then this thing blows up and it makes $1 million. Developer says, all right, where's my $500,000? And I say, what are you talking about? If I paid you, your rate would have been $250 an hour, I'd pay you, $100,000. That's what I'm going to pay you, $100,000, because that's what the cost of development was. And developer says, what are you talking about? I did all this on the intention, on the basis that I'd be a partner with you, and it's my work. Okay, so problem number one is, if a business owner didn't have a contract, then I'm going to have to fight about whether or not we created a general partnership. And under the default general partnership rules, then you would argue that the code is owned by both, and it can get really messy. So you always want an agreement. I don't care if it's your brothers, whereas, yeah, I don't care if it's your family. If you want to, you need to treat this code as an asset because it's property. And when you break up with that person inevitably, you will need to figure out how to divide that asset, and it becomes like anything else. Someone's got to buy the other person's out, or you have to agree to both get to use it, or something has to happen with it. It's not de facto owned by one person or the other. And the other scary thing about a joint authorship scenario is that, let's say someone approaches me, let's say it's a really disgusting organization, the KKK. Okay, come up whatever you want. And they say, we really like what you're doing with your code. We'll give you $1 bazillion to use it for whatever, our KKK purposes. And I'm like, I don't really like the KKK, but I like $1 bazillion. So okay, I'll take it. And then my partner, Shaq, is like, what are you doing? Why would you do this? How could you sell the code to this terrible place? Can he stop me? Who says yes? Says no. Who says he should be able to stop me? All right. So here's the scary thing with joint authorships, and this is true whether it's a book, it's with any creative work, is that a joint author's only duty to his joint author, the partner, is a right of accounting. So what does that mean? I make $1 bazillion. I negotiated the deal, but I only own half the copyright. I got to give him $500 million. But he can't stop me from exploiting, licensing the code or the work, because it's kind of like that house. Where is that picture? Let's say we buy a house together, and I want to bring my friend Cindy over, or I want to throw a huge party. We both own the place, so you can't stop me from inviting who I want to the place. If I want to paint the place fuchsia, it's my house just as much as it's his, so we both own it. Now, if I sell the house, I don't get to keep all the money. I've got to give him whatever his ownership in that house is. So both names are on the title. Right, it's essentially the same concept. So contracts. So let's talk about contracts before I go to trademarks. And I have, 7 minutes-ish, 10 minutes? Okay, I think that'll be enough. All right, so we talked about the importance of partnership agreements. If you're doing any sort of work for anybody or with anybody, you need a contract. That contract will tell you who owns what happens if you break up, what happens if you want to bring someone else on. These are all really important provisions in any sort of partnership agreement. But more likely or not, as an employee or as someone who's pitching a concept, you're going to be asked to sign a non-disclosure agreement or a confidentiality agreement. 90% of those documents are boilerplate and essentially worthless. Why? Because they're so boilerplate. And I get this, I'm not going to tell you the idea until you sign an NDA. And I say, okay, first of all, FYI, with an attorney, there's an automatic privilege. So you don't need, you get your attorney to sign an NDA because the attorney has to keep things confidential. But let's say you ask your friend to sign one. All right, I've got a great idea for this project. Sign the NDA before I tell you about it. Okay. Remember that the idea for something is not protectable, typically. And so NDAs are a good layer, it's good practice, but if you ever had to enforce that NDA, you'd have to explain why whatever you related is a trade secret or has some inherent value because of its, because of what it is. That it's not readily accessible or you had to do something extra to get that information and relate it. So usually you have to be very specific about whatever it is you're relating before you relate it without telling them what it is. You want to mark things confidential before you hand anything over. And as a best practice, if you're in the process of pitching something, don't give them everything if you can in order to engage. Give them as little as you need to start that conversation. Now on the ancillary side, if you're an employee or you're being hired on a project and you're asked to sign a confidentiality agreement, that's essentially saying, hey, by virtue of developing whatever it is I'm asking you to develop, you're going to get access to financial information, business processes, all of that you better keep secret, or else we'll sue you if you ever leave or try to take that information to somebody else. So you'll be asked to sign a non-disclosure agreement or a confidentiality agreement, and sometimes you might also be asked to sign a non-compete. Non-competes are enforceable only, different states have different standards of whether or not a non-compete's enforceable. California hates them. Illinois doesn't mind them. Illinois is more, I say, corporation heavy. So long as the non-compete is limited in time, in scope, in geographic location, then typically they'll be enforced. And the average is from a year to 2 years, depending on what the skill is that you guys are offering, whatever the work is that you're doing. Sometimes a non-compete's not feasible. Like you have to be able to do X, Y, Z job, and if they tell you you can't work for a year, they're not going to stop you from making a livelihood. So the next one would be a non-solicit. Sometimes you see all three things, sometimes you just see one, sometimes you see two. A non-solicit typically says that if I work for company X and I leave company X, I will not take with me any of company X's employees, and I will not take from company X any of its clients or customers. I will not solicit them. And then you get into litigation over you leave and the client comes to you directly and you do the work, and then they say, well, I didn't solicit them. They came to me, and then you're like, well, you're under contract not to take the work, and then we make lots of money. So that's how that works. But if you want to be careful, you want to negotiate that when you start the job. If you have any leverage, you want to reduce how long that non-compete or or the scope of that non-solicitation is. So those are some of the important things to think about when you start that. All right, so the last topic is this concept of trademarks. If any of you are working on projects or you really have a cool app or whatever it is you're making and you want to brand it, that's what a trademark will cover. So copyright covers the actual creative content. Trademark is the source, is the name that defines what the source of the product or good or service is. So we've got some of these. Trademarks can be also applied to the way something looks. So that's called trade dress. The example I typically give is if you come home with a turquoise blue box and you give it to your spouse, significant other, what would it be? I just gave you the color and I said it's like a box. So you knew that from that's a Tiffany box. Smells can be trademarkable. You walk by someone and it's like Chanel No. 5. You know that's a trademarked scent. Play-Doh is trying to trademark the smell of Play-Doh, if you saw that. So there's a lot of things, as long as they're being, for your purposes, it's probably going to be a logo, a slogan, or a name. Trademarks range from generic to really fanciful. And a lot of times people will create an app and upload it to the App Store or whatever it is, and they'll get bounced because the name is too close to an existing application. So you really want to, before you invest heavily in promoting or in, creating collateral around your brand, you want to do a search to make sure that the mark is available. And even before that, you want to make sure you're not picking a name that's so descriptive or generic that it's not inherently protectable as a trademark. So if I want to call my phone company Phone, and maybe I have a cool logo, but the name is Phone, I can't get a trademark because other people need to use the word phone to describe the product phone. The best marks are made-up words, but if made-up words are hard to market. If it's XYZ phone, you have to spend more money explaining what XYZ is. So there's this kind of continuum of where you want to be on that scale, but as a best practice, you want to make sure that you are searching before you start the name to see that nobody else has it. Trademarks cost $275 typically per application per class. So trademarks are filed per class, and if you are like downloadable software, that's class 9. If you're just a service, that might be class 35. Sometimes you might have to file the same word in multiple classes, so you multiply that fee. So think about what you need to protect and what classes you need to protect it. How long do trademarks last? Nope, unlike a copyright, trademarks are premised on, you have trademarks so long as you use them. So if you stop selling a product or advertising that product or make it available for sale, you're no longer using it. And at about 3 years is what the standard is. It's considered abandoned if you stop using it for that period of time, and someone else can start using that name. So trademarks are only as good as your use. And in fact, in America, to get a trademark, you have to actually show use. So you can file what's called an intent to use application to preserve your name, like as a placeholder. And assuming a mark gets through, then you have a period of time, up to 3 years, if you keep paying extension fees, to show, hey, OK, I'm actually affixing this name to this app, this code, this product. Please give me the trademark registration. Trademarks are country by country. Copyrights are protected under something called the Berne Convention, so there's kind of this international treaty. Trademarks, typically you have to go to each country to file the registration in to get protection in those other countries. So something to think about there as well. That's kind of what I have, but it's exactly 8. If you have any questions, let me know. You can get me at saperlaw.com. Yeah? No, because Facebook's a big company. So I have a client, I represent 4Loco, the drink fusion project, which has 4Loco. You guys anyone drink that? OK, so it's amazing. We manage their international trademark portfolio. They're like, Daliah, please file trademark in Nigeria and Haiti and like Libya. And I'm like, really? Some of these are Muslim countries who don't even allow alcohol. Like, why are we registering here? Just trademark it there. So we have a network of lawyers that we manage from each of these countries to ensure that no one tries to go and take that name. And it becomes an issue with distribution, especially if you're selling hardware or packaged software. Each country typically premises it on use as well. Some are based on first to file. So it's really important to get your stuff in order before you allow distributors or anyone else to sell that software. But pirating is a big problem, and especially with code, right? So sometimes just have to put in other mechanisms to make sure that no one's. Legal is the last route to protect your software. A contract's only as good as your ability to enforce it. So if you make it tough to get the code, or you have only one repository, that always makes more sense than having a really awesome contract that someone signed. Can you trademark a URL? Yes, if the URL is what you're using as the brand. If you're Amazon.com, which it used to be instead of Amazon, then you can trademark Amazon.com. But if you're Amazon.com and on the page, the URL page, the word is like XYZ, then your trademark's XYZ, not XYZ.com. No. Our contracts enforce the same in different countries. So most contracts will have a choice of law provision, and that's something we'll negotiate too, even within the United States. If there's a dispute, you agree to litigate this in Cook County, in Illinois versus in California. And if, hey, your lawyers are in Illinois, you want the case to be litigated here. Well, OK, so I'm in River North. I'm not far. If you guys have any questions, feel free to reach out to me. Some version of this presentation is online. I did it at the Windy City, what was it called, Code Windy City Rails, I think. I did that a few years ago. Yeah.